Welcome back to our channel, Maduabum Law Firm LLC. We are going to be talking about adjustment of status from a B1, B2 visa category. Adjusting your status from a B1, B2 visa to a permanent resident status in the United States is a significant step that requires careful planning and compliance with U.S. immigration laws. Whether you're in the U.S. for business, B1, or tourism, B2, transitioning to a more permanent status involves several legal considerations and procedural steps. To adjust your status from a B1, B2 visa to a permanent resident, green card holder, you must meet specific eligibility criteria such as 1. Be an immediate relative of a U.S. citizen, spouses, unmarried children under 21, and parents of U.S. citizens can adjust their status. 2. If you have an employment offer and qualify for an employment-based green card, you can adjust your status. 3. Individuals who win the diversity visa lottery can adjust their status if they meet all the requirements. 4. If you have been granted asylum or refugee status, you may adjust your status after 1 year. Before beginning the adjustment process, confirm that you meet the eligibility criteria. Consulting with Maduabum Law Firm LLC Immigration Attorney can help clarify your eligibility and the best path forward. The next step is to file Form I-130 or Form I-140. If you are adjusting based on a family relationship, the U.S. citizen relative must file Form I-130, Petition for Alien Relative. If you are adjusting based on an employment offer, your employer must file Form I-140, Immigrant Petition for Alien Worker. For family-based petitions, you must wait until a visa number becomes available according to the visa bulletin published by the U.S. Department of State. Immediate relatives of U.S. citizens do not have to wait for visa availability. Once a visa number is available, or if you are an immediate relative, you can file Form I-485, Application to Register Permanent Residence or Adjust Status. Along with Form I-485, you may need to submit Form I-693, Report of Medical Examination and Vaccination Record, Form I-864, Affidavit of Support, if applicable. Supporting documents, birth certificates, marriage certificates, proof of lawful entry, etc. After filing Form I-485, you will receive a notice for a biometrics appointment, where your fingerprints, photo, and signature will be taken for background checks. Next, you may be required to attend an interview at a USCIS office. During the interview, a USCIS officer will review your application and supporting documents and ask questions to verify the information provided. Adjustment of status from a B1, B2 visa has some red flags USCIS look out for. One of the primary challenges is the inability to sufficiently demonstrate that you did not have immigrant intent when you entered the U.S. on a non-immigrant visa. USCIS may scrutinize your case to ensure you did not misrepresent your intentions when applying for your B1, B2 visa. Secondly, filing for adjustment of status too soon after entering the U.S. on a B1, B2 visa can raise suspicions of visa fraud. It is advisable to wait at least 90 days after entry before filing Form I-485 to avoid the presumption of fraud. While your adjustment of status application is pending, it is crucial to maintain lawful status. Unauthorized employment or overstaying your visa can jeopardize your application. Adjusting your status from a B1, B2 visa to a green card is a complex process that requires careful planning and adherence to U.S. immigration laws. Consulting with an experienced immigration attorney at Maduabum Law Firm LLC will provide invaluable guidance and increase your chances of a successful application. By understanding the eligibility requirements, preparing thorough documentation, and following the necessary steps, you can navigate the adjustment process with greater confidence and ease. We have come to the end of today's video. Thank you for watching. Please subscribe for weekly immigration updates.